Hi there, my name is Alex Monaco. I'm a solicitor. I have my own law firm called Monaco Solicitors, and we specialise in employment law representing employees only. That's you, hopefully. Now, I'm going to do a short video on the merits of SARs, which stands for Subject Access Requests. You might have read a little bit about this on our website, monacosolicitors.co.uk. On there you can find an article about SARs and also a number of example SARs for you to adapt and use in your case. Now, what is a subject access request? It's basically a letter which you write to your employer whereby you request a copy of your HR file or your employment file, and it's sitting under the data protection legislation which we have in the UK. So the Data Protection Act gives you that right, so that any data which relates to you and which is stored by any organisation in the UK, including your employer, you have a right to request that. Now, this is very useful to a useful tool to implement in your employment law case, especially when you're trying to negotiate a settlement agreement, because you can find all sorts of things that the other side, i.e. HR or the dark side, as we like to call them, didn't want you to know about their internal chat about you. Now, as you can see on the example SAR letters on our website, you can specify the types of communications that you want copies of. So emails, WhatsApps, even, and SMS text messages, obviously letters, and other forms of written communication. And what you can also do is you can specify the search terms which you want them to use, because nowadays they'll run a search on their computers, because most communication is done by email or other electronic methods. So you can specify the search terms, so it'll be anything with your name in it, and then you can specify the people who it might be between. And what you can find is that, for example, you might be getting constructively dismissed from your job, or you might be getting managed out, forced to leave, or they're trying to force you to resign by making your life hell without giving you a fair deal, a fair exit package or settlement agreement. Which is what we specialise, by the way, in negotiating for our clients, which is for yourselves, the employees. Anyway, quite commonly an employer will try to get rid of someone without giving them a fair deal, because it will save them money. So if you do a subject access request, then the other side have got 40 days to provide you with all the evidence or documentation which contains the search terms, including your name. You might find a wealth of information. Sometimes you can find an absolute treasure trove, whereby they've been talking amongst themselves about how to get rid of you, what can we do him for, can we get him for gross misconduct? No. What about redundancy? No. Oh, well, let's just try and manage him out, or her, obviously. So once you've found that kind of communication, if you're lucky, if you do find that, then you can use that in a tribunal case, or in the shorter term, you can use it in a negotiation, which will then obviously boost your negotiating position, give you that advantage that you can then put the other side on the back foot and get yourself a decent deal from them. Now, obviously, you might not want to do that yourself. You might want to call us, and we could do that for you. There's a lot more info on our website, so get in touch if you'd like to know more. Thanks a lot. Bye.